Hello, my name is Richard Silver. I'm a solicitor with Bexley Beaumont Solicitors in the field of construction. My background is in construction, having held roles of Chief Surveyor and Construction Director. I'm a Fellow of the Royal Institute of Chartered Surveyors and also a panel adjudicator. My son and I are, over the coming weeks, going to present a series of seminars on a number of construction issues. This morning, I'm going to cover the topic of contract formation. It is, in my view, one of the most important aspects of any construction contract dispute. You can only determine a dispute if you first know the terms applicable to the construction contract. When I worked in construction, and I was on site, I held roles of site surveyor and site agent and contracts manager. It was very unusual if we actually had a copy of the contract on site. If we did, it was generally a standard form. We didn't have all the amendments, we didn't have all the other documents. And the only ever time we really looked for a copy of the contract was when something had gone wrong. So the issue is what's the relevance of the contract? Why do you need it? And do you only really need it when things go wrong? Well, the answer to that is that a contract does two things. First of all, it sets down procedures. It tells you what you should do in certain circumstances. The second thing it does is it allocates risk. Prime example of risk is if it is a lump sum contract compared with a cost reimbursable contract. With a cost reimbursable contract, the risk lays with the employer. They have to pay whatever the costs incurred by the contractor are. The risk is far greater with the employer than the contractor with regards to price certainty and the amount to be paid. Another factor to look at is, for example, delays associated with exceptionally adverse weather conditions. If one's on a JCT contract, the risk is split. The contractor can get an extension of time but no loss in expense. If one compares that with the unamended NEC form of contract, the contractor for exceptionally adverse weather conditions will get both time and money. So for the exact same events, the entitlement may be different. So therefore you can see the importance of knowing the contract and the applicable terms. And I should add, it's very, very rare that you get a contract which is unamended. And if you do have amendments, those amendments generally change the procedures and the risk profile, more often than not, in favour of the employing party. So let's delve into this a little bit deeper and let's give us an example, a subcontract. When I was a surveyor on site, the procedure was generally this. Job started and a large box of papers were delivered to site. I'd go through them and find all the tenders that were submitted by subcontractors and suppliers, and I would look to place orders for those works. I wouldn't simply accept those tenders. I would be required to go out and get alternative quotes, seek to negotiate the prices and get as low a quote as possible. To do that, the first step was to send out invitations to tender. Those invitations would include details of the contract, the project, the duration, what was required to be undertaken, etc. I'd then get the tenders back. And the first problem nearly always was that the tenderer, the subcontractor or the supplier, would say that their terms would apply. My invitation to tender, however, said that our terms, our standard terms would apply. So the two didn't exactly match. Having obtained the relevant subcontract tender, we would then meet for a pre-contract meeting. That pre-contract meeting always stated at the top, this shall not form the contract, but shall form part of the contract. So even though we had a pre-tender meeting, pre-contract meeting, it didn't necessarily mean we would place the contract with them. During that meeting, we would go through various factors. For example, what were the terms and conditions, start dates, completion dates, etc., etc. Having then agreed those pre-contract meeting discussions and meeting minutes, we would then issue a subcontract order. But the subcontract order wasn't in the terms of the tender. And then nothing. Quite often the contract wasn't returned. No one worried about it until 6 months later when everything had gone wrong. The job was either in delay, um, variations were claimed which we said were included. There were claims for loss and expense. We were thinking about damages. The works weren't carried out to our mind correctly. And in order to determine those nature of problems, the only way you can do it is to look at the contract. Now, as I said, in this scenario, the subcontract's not signed. So if it's not signed, is it in fact a contract at all? And this is where we get to basic contract law. In order to have a contract, you need 4 essential elements. 2 of them don't really concern us too much, which is consideration and intention to create legal relations. What I want to concentrate on is the 2 main elements being offer and acceptance. So, offer. The initial invitation to tender that we issue is not an offer. It is asking for an offer. An example of that is when you go into a chemist. If you go and pick up certain items off the shelf, actually, and you take them to the till to pay for them, you taking them to the till is the offer. The items being on the shelf is actually an invitation to tender. It's an opportunity for you to offer to pay for that item at the price it is set at, and then the person at the till taking your money is the acceptance. In construction, it is only the tender that is the offer. The next question is how long is that tender open for? If the tender says it's open for 6 months, it's open for 6 months. But what happens if it's silent? Absent any restriction or limitation on the period that the tender is open for, it is open for a reasonable period. What's a reasonable period? Well, that will depend upon a number of factors, and if you can't agree it, there is legal processes to try and determine for each particular tender how long it's open for. But quite clearly, if you submitted a tender today for a construction project, it is extremely unlikely, unless you've agreed otherwise, that it is open for 6 months, 2 years. So let's go back to our situation with the buyer having obtained tenders which have been included within your tender for the works. If you've obtained a number of tenders, one of the biggest problems when I was a QS was I would phone up the subcontractor, the supplier, and say that you tendered for certain works 6 months ago. We'd like to place the order with you. And they say, well, I'm sorry, we don't want to do the job anymore. Or our prices have gone up. And that would cause me a major problem as a quantity surveyor. If you want to overcome that, you actually have to make their offer a contract in its own right. And in order to do that, you need to have an offer and acceptance. So by doing that, you could say, we would like you to tender for the works, and we would like you to keep your tenders open for 6 months, and for which we will pay you £1. They then submit the tender on that basis, you pay them £1, and that tender is now a contract which must remain open for the 6 months as agreed. One way of getting around it. Going back to our scenario, however, we've got the situation where a subcontractor has submitted an offer and their tender, the offer, includes their terms. In order to accept it, we must do something that exactly matches the offer. So if we accept it, we have to say, we accept. If we want to do it in writing, we must simply sign our name. We mustn't make any changes to the terms. So if I write back having received the tender and say, we accept, subject to our terms and conditions, that's not an acceptance, that's a counteroffer. And that's where we get into problems in construction projects. It's called the battle of the forms. We get a tender issued, it says its terms and conditions apply. We get a subcontract issued, it says its terms and conditions apply, and then neither party signs or agrees to it. And we then get a problem and determine if any contract has actually been formed. Now, as I mentioned, a subcontract more often than not is a counteroffer because it includes terms that are different to the tender. What is the effect of a counteroffer? Well, a counteroffer rejects all previous offers that have been made. So if someone submitted a tender and you then send a subcontract order saying our terms and conditions apply, which is contrary to the tender has been rejected and therefore cannot form part of the contract. So let's just move the next step. We've had a tender, it says its terms and conditions apply. We've got a subcontract, it says its terms and conditions apply. And then the party starts on site. That is conduct. By starting on site, the subcontractor has in effect accepted the contract that was issued. But what happens if they started on site prior to receiving the contract? You can't accept something that you've never received. So starting on site can't be acceptance of the contract which had not been issued. However, it could be that the contractor, in allowing the subcontractor to start, has actually accepted the subcontractor's previous tender. So when we're looking to try and establish an offer and acceptance, we must A, establish what the offer is, B, make sure there is no counteroffer thereafter, and C, that the acceptance follows the offer. And the acceptance can take one of three forms, being either in writing, orally, I accept your quote, or by conduct, in doing something that indicates that you accept, for example, starting works on site or allowing the other party to start on site. So I'm now going to give you an example. I was involved in a dispute where a party was seeking extensions of time and loss and expense and had been deducted liquidated damages. In order to determine the dispute, I was required to look at the contract which they issued to me. I looked at all the contract documents and the first thing I noticed was there was no signed contract. I then looked through the invitation to tender and it referred to one form of contract. There was then the pre-contract meeting minutes which referred to another form of contract. I then looked through the contractor's notices and that referred to another form of contract. When asked what had gone on, the contractor said that because they never received a copy of the contract, they relied upon the most recent form of JCT form that had been issued. What I found, therefore, was in fact there was no contract, there was no provisions for liquidated damages, there was no need to seek an extension of time, and the contractor was entitled to quantum meruit, a reasonable amount. It was a simple contract. On such basis, the contractor was effectively avoided the necessary obligation of proving extensions of time, could obtain what its actual cost was, and was found to be in a much better position than it would have been had it actually had a contract placed with it. I hope that's very useful. If you've got any other questions, please do give me a call or my son Brandon. And I hope you'll be attending our next seminar. Thank you. Bye-bye.